My name is Chiara Altafin, and I work as a research manager at the Global Campus of Human Rights Headquarters based in Venice, Italy. It is my great pleasure to participate online in this international conference on the access to justice for children in the Republic of Korea. Since September 2020, I've been leading the global study component within the project ACRILS, Advancing Child Rights Strategic Litigation, which is a project coordinated by Professor Yves Nolan from the University of Nottingham, UK. ACRILS is a global research collaboration bringing together partners from advocacy and academia, such as the Human Rights Law Center of the University of Nottingham, the Center for Child Law of the University of Pretoria, the Human Rights Institute of the University of Deusto, the Global Campus of Human Rights, and in particular its follow-up program of the UN Global Study on Children Deprived of Liberty, but also the European Center of Human Rights based in Berlin, and the Child Rights International Network, and the Impact Law for Social Justice. Under this project, child rights strategic litigation is defined as litigation that seeks to bring about positive legal and or social change in terms of children's enjoyment of their rights. Focus on the development, implementation, impact assessment, and critique of child rights strategic litigation from a child rights perspective. This project is contributing directly to strengthening the capacity of such litigation to deliver on children's rights globally. It is doing so through a continuous exchange between research and practice, academia and advocacy. It is structured over 3 years, and this project will deepen practice and research collaboration synergies between advocacy and academic partners in this area, with the common goal of advancing children's enjoyment of their rights. It will do so by contributing original research towards the improvement of child rights strategic litigation in practice, and also by bringing and supporting a series of child rights strategic litigation cases before national, regional, and international decision-making bodies. Under the project, whether a case qualifies as child rights strategic litigation depends on a number of factors. In particular, the process that led up to the case, the way in which the case was developed or shaped by child rights during litigation, both in terms of legal argumentation and in terms of litigator practice. Also the remedy granted and the outcome of the case, both legal and extra-legal outcomes. In this context, two important questions remain: who are the litigants and or the litigators, and what is the objective or what are the objectives of the litigation? A key objective of the project is to map existing child rights strategic litigation practice. This entails gathering and collecting information on who is doing or has done such litigation, on which child rights related topics, where and before which bodies. This has led to create an open access public database which collects key child rights strategic litigation cases identified by the project partners, and which will be updated throughout the lifetime of the project. And there is a specific link in this regard provided in my PowerPoint presentation. ACRILS focuses on different thematic issues, for instance, migration-related litigation, children's environmental rights, but also children deprived of liberty. And I am leading exactly specifically the implementation of the ACRILS component related to the recommendations of the United Nations Global Study on Children Deprived of Liberty, which was launched in 2019 by the independent expert leading the study, Professor Manfred Novak. And in the context of ACRILS, we are focusing specifically on one of the thematic issues of the global study, that is migration-related detention of children. In particular, this component has entailed to carry out practice-oriented research and regular engagement with selected legal practitioners in order to provide them with support, whether financial or otherwise, in the form of amicus curiae, third-party interventions, expert opinions, or also technical capacity in argumentation, for cases litigated in Europe or in Asia, to advance children's rights in the context of migration-related detention by means of strategic litigation before domestic, regional, and international courts and monitoring bodies. The main outputs of this specific component have included so far an amicus curiae brief prepared in relation to an individual communication against Poland before the United Nations Human Rights Committee in a case about a single father and two underage children who were placed over 10 months in a guarded center for foreigners. Another output has been the amicus curiae brief prepared in a case of cassation appeal before the Polish Supreme Court, which concerns compensation for wrongful prolonged detention of a mother with her child. We also supported 5 cases against Greece before national administrative courts to prevent concrete risks of detention of the migrant children concerned, and also to protect a child who experienced unlawful migration-related detention with adults for 4 months in Greece. Moreover, we supported 2 cases against Malta before national courts and the European Court of Human Rights to flag Malta's excessive and irregular reliance on administrative detention of children as a tool of immigration management, as well as underlying the institutional abuse presented by the cumulative effect of various procedures and the terrible living conditions in which children were kept in the state detention centers in Malta. Finally, an important other output of this component is represented by the expert opinion prepared for the Constitutional Court of the Republic of Korea in relation to the constitutionality of a provision of the National Immigration Act, which represents a legal ground for indefinite detention of migrants in a specific case concerning an unaccompanied child. I would like now also to highlight some key resources so far produced within the ACLES project. In particular, a report published in September 2022 by Professor Nolan together with the Professor Skelton and Advocate Osaka. A report titled Advancing Child Rights Consistent Strategic Litigation Practice, and the related key principles for child rights consistent child rights strategic litigation practice. The authors of these research outputs especially highlight that child rights are an increasing focus of strategic litigation efforts with growing range of actors bringing cases in different legal contexts. However, in child rights strategic litigation practice, child rights have primarily played an outward-facing role. In fact, they have been treated by practitioners and others involved in planning and implementing strategic litigation as a schema that should constrain or mandate the actions of external decision makers that are the targets of the strategic litigation. Instead, the ACLES project focuses on child rights as a lens to be turned inwards by those carrying out such litigation to consider the extent to which their practice is consistent with child rights standards. In fact, certain elements of the United Nations Convention on the Rights of the Child represent a framework particularly important for use by practitioners to inform and assess the inputs, outputs, processes, and outcomes of child rights strategic litigation, in line with the view that children's rights set out in the CRC can and should play a role with regard to shaping and informing litigation practice. This is argued under the assumption that where child rights strategic litigation efforts aim to advance children's rights through legal and social change, but are inconsistent with children's rights in terms of how they are operationalized, then their legitimacy is weakened, as well as their internal coherence and capacity to contribute to children's rights achievement in practice. According to the authors of the aforementioned key resources, there is not a one-size-fits-all approach to child rights strategic litigation, and the context remains important, drawing on concrete experiences to translate child rights consistent practice from abstract rights framing to reality. A child rights framing does not provide all the answers, but it is important for practitioners to consider children's rights as appropriate when it comes to decision-making on the conceptualization and operationalization of their child rights strategic litigation-related work. In this regard, the aforementioned authors have also highlighted the rights most directly engaged in child rights strategic litigation practice. In particular, Article 12 on the right of children to express their views and for those views to be given due weight. Article 13 on the right to freedom of expression. Article 17 on the right to information. Article 5 on the evolving capacities child. Article 2 on the principle of non-discrimination. Article 3 on the best interest principle. Article 6 on the right to life, survival and development. Article 19 on the right to protection from all forms of injury or abuse, maltreatment or exploitation. And also Article 36 on the right to protection from all other forms of exploitation prejudicial to any aspect of the child welfare. Article also 39 on the duty to take all appropriate measures to promote physical and psychological recovery and social reintegration of child victims. And finally, on also Article 4 on appropriate legislative, administrative, and other measures for the implementations of the rights in the CRC. It is also worth highlighting that we are developing a network of people and organizations working on child rights strategic litigation. The network is made up of academics, legal professionals, NGOs, IGOs, national human rights institutions, and others interested in such a type of litigation work from a wide range of perspectives. The network will enable the sharing of information about past, current, and planned litigations, as well as with regard to child rights strategic litigation more generally. And during the lifetime of the project, we will organize a number of different events and activities involving network members around key issues related to children's rights strategic litigation. For example, on the issue of ensuring child participation in such litigation, as well as the implementation strategies around child rights strategic litigation. Therefore, if you are interested in joining the network, please complete this form that is indicated in the link provided in my PowerPoint presentation. I thank for your attention, and I wish you successful and fruitful discussions in the context of this very important conference.